Your Honor, I've actually prepared something that I'm going to be reading for you all, and especially after Mr. Skrinsky's, what he just had to say, I'm actually quite eager. First of all, I'd like to thank the court for allowing me the opportunity to speak on the record before my sentence is imposed. The event that's brought all...
Right from the beginning, you can hear the strategy in his words. He opens with sympathy and regret, but carefully avoids directly admitting guilt. That a very calculated move, often seen in high-stakes courtroom speeches.
All of us here today was nothing short of an absolute tragedy that's affected the lives of a lot of people. And I want to express my deepest condolences and sympathies to the members of the Cipriano family who were affected by this incident. You know, I never intended for any of this to happen. And every day I deeply regret the fact that I was unable to stop it. I never once thought that my association with Tucker Cipriano would lead to an event like this. That being said, I once again want...
And here comes the turning point. This is no longer just a sentencing statement. It's becoming an appeal argument in real time. Claims about missing evidence, unfair treatment, and ineffective counsel are all major legal issues that appellate courts examine closely.
To state that I am not guilty of the 5 crimes I am to be sentenced for today, and I do intend to file for my appeal as soon as possible following the conclusion of this hearing. Now I'm going to cover some, but not all, of the issues that I intend to raise on my appeal, and I ask you all to please keep in mind that while some of what I have to say may seem motivated by anger or frustration, it's not my intent in any way to be inflammatory, merely to point out the things that I feel strongly represent a miscarriage of justice in this courtroom. Starting with the fact that I was not provided with, nor did I have an opportunity to examine all of the documents, photographs, and other paperwork that the prosecution intended to produce against me at trial, despite my request per MCR 6.201. I was not provided with the opportunity to inspect all tangible physical evidence that the prosecution intended to produce against me at trial, despite my request per MCR 6.201. I was not provided with any criminal record of all the witnesses the prosecution produced or intended to produce against me, despite my request to the same MCR. This list continues further, but in short, I was not allowed the opportunity to properly prepare my defense due to the lack of information in the discovery with which I was provided. I do not know why I was not provided with this information, but the why does not change the fact that my requests for information that I had every legal right to were completely ignored. And this brings me to the subject of Michael McCarthy, my court-appointed attorney, and I would like to thank you, Michael, for the things that you had to say on my behalf. They were very kind, but unfortunately I also do have to bring to attention, I do have to bring to attention that I'm not satisfied completely with the counsel that you have provided me. I believe there were many things that should have been done that weren't. As Michael McCarthy said, he and I have met countless times over the course of this case where I expressed my concerns and expectations involved in my defense. Unfortunately, these expectations were not met. I presented Michael with the names of witnesses who I wished to be called to testify on my behalf at trial, and to my knowledge, Michael did not so much as interview these individuals, and my request went ignored. During our meetings, I brought to Michael's attention numerous points that I wished for him to present at trial, and despite his assurances to me at the time, he neglected to address many of these issues. Among these were the defenses that I requested that he present. These included abandonment, claim of right, duress, and the mere presence defense.
Now things get serious. Accusing your own attorney of failing to present key defenses is a huge allegation. In the legal world, proving ineffective assistance of counsel is incredibly difficult, which makes this moment especially dramatic.
4 defenses that I found to apply to my circumstances, all of which were agreed to at the time of my request, only mere presence and duress were presented. When I questioned Michael on this at trial, he remarked to me that at that time nothing could be done about it. In doing this, he impeded upon my constitutional right to present my defense. No witnesses were called in my defense. My requests for various types of expert witnesses went ignored. No defense exhibits were prepared whatsoever for the jury. Witnesses were not confronted on multiple contradictions and inconsistencies that were present in their testimony. Points that I practically harped Michael on that were key in my defense were entirely neglected, and timely objections were not made where they were due. It is for all of these reasons compiled together that I submit that I was not given effective assistance of counsel. I'm not trying to beset in any way Michael McCarthy's reputation. I'm not trying to say that he isn't a good attorney. He's very experienced, and he is effective, and the arguments that he presented were very persuasive. But what I am saying is guarantees and assurances that were made to me by him were not fulfilled, and the needs of my defense were not met. Now to broach on the aforementioned inconsistencies in witness testimony. The first witness the prosecution produced was the female operator who received Tanner Cipriano's 911 call. By her own testimony, she stated that her recollection of the call was fuzzy and that it was difficult to hear the caller because he was whispering. Despite this, she was able to confirm that the recording was true and accurate. Beyond that, she confirmed that the transcripts were a true and accurate representation of the recording. I failed to see how, if her memory is fuzzy, her word, that she could confirm with a 100% certainty that the recording and transcripts of the recording were true and accurate, especially considering that because the caller was whispering, it was difficult to hear in the first place. I brought this point to my attorney's attention, and he neglected to address the issue at trial. In fact, he refused to cross-examine the witness whatsoever. Now to talk about Ian Zinderman and his testimony. Every time this man has said something, it has been changed. His preliminary...
Notice how detailed and methodical he becomes here. He's analyzing testimony almost like a lawyer himself, pointing out contradictions, memory gaps, and inconsistencies one after another, whether convincing or not. It's clear he studied every detail of this case.
Examination testimony was so inconsistent and contradictory that it would have been comical had the implications of his statements not been so grave. I was able to count well over 20 blatant contradictions that he made to his story in just the first line of questioning by the prosecutor at preliminary examination. That was before any cross-examination had even begun by my attorney. The truth doesn't change. His preliminary examination testimony contradicted his previous statements to the police, and his testimony here in this courtroom contradicted both his previous statements to the police and his preliminary exam testimony in numerous ways. He even provided a convenient excuse for all of these changes and contradictions, and for the difficulties he had in processing the questions posed to him by my attorney. Partial complex seizure disorder was the excuse he presented. However, at preliminary exam, he was specifically asked if he suffered from any physical or mental disabilities. His response at that time was that he had, and I quote, a math deficiency, and went on to state that he believed he had both ADD and ADHD. Partial complex seizure disorder was never mentioned previous to trial. I brought this point to my attorney's attention, and he neglected to address the issue at trial. Oddly enough, this disorder of his only seemed to present Ian with any difficulties in processing information when he was being questioned on cross-examination by my attorney. Another reason that he provided for his multiple prior inconsistencies was that he was in shock and confused at the time of preliminary examination, but that after he A, repeatedly conferred with the prosecution to review his story, B, catered his story to match some of the evidence that it previously contradicted, and C, prepared his testimony for trial, he's testified that he had it all straightened out now. Big surprise there. He testified also that he remembered things more clearly now, a little over a year later, than he did at preliminary exam. Yet when he was confronted on who actually said what, he attributed the fact that he could not recite a single complete sentence and identify the speaker to the fact that it was over a year later, and that he could not clearly remember. All he was able to do was attest to the general idea.
The judge steps in here for an important reason. She's reminding him that sentencing is not the place to fully argue an appeal, but by allowing him to continue. The courtroom gets a rare glimpse into just how emotional and personal this case has become.
Of the alleged conversation. Yes.
And this is not your appeal. Everything that you're saying now is your basis for your appeal, but the appellate court needs to hear.
Yes, Your Honor. I need to get this on the record.
Well, we're going to make a record in the appellate court. You don't need to say all of this today, because all of this is going to be on record when you send a brief up to the appellate court
I do, Your Honor. Thank you.
I mean, we're addressing your sentencing today.
I understand. Also, a lot of this is just things
Don't
that...
interrupt me, Mr.
I'm
Johnson.
sorry.
We're addressing your sentencing today, and you're allowed to speak to the court with regard to your sentencing. Everything that you want to put in an appeal brief for the appellate court, this is not a proper form for it today.
Okay, I understand.
You're free to say what you want to say.
Thank you, Your Honor. And it's not only for the purpose of the appellate brief that I'm saying these things today. I want people to know that while I'm a 21-year-old man who has never had any legal experience in his life aside from what I've had in the past few months that have led up to this, the past year that has led to this trial, I clearly recognize these points that I brought to Michael's attention that were not addressed. And I'm sorry. He attributed the fact that he couldn't recite a single complete sentence and identify the speaker to the fact that it was over a year later and he could not clearly remember. All he could do was attest to the general idea of the alleged conversation. But at preliminary examination, every time he was confronted on who the speaker was, he either identified Tucker Cipriano or claimed not to remember, and that was only a few weeks after the incident had taken place. I brought this point to my attorney's attention, and he neglected to raise the issue at trial. Ian Zunderman's testimony was key in the prosecution's case against me. Therefore, impeaching his credibility as a witness and bringing to light the staggering number of changes, contradictions, and inconsistencies that he presented was paramount in my defense. I had repeatedly requested Michael McCarthy on countless occasions that every single change, every single contradiction, and every single inconsistency, from the beginning of this incident until now, involving Ian Zunderman be presented before the jury, and despite the repeated assurances made to me at the times of my requests, that was not done. I requested that an exhibit be prepared for the jury depicting Ian Zunderman's previous statements and testimony. That way, when my attorney confronted him, the jury would be able to see for themselves the extent of Mr. Zunderman's lies and deceit. Despite the assurances made to me at the time of my request, my attorney neglected to prepare any exhibits to be presented in my defense. I requested that Ian Zunderman's criminal record and history be prepared and used for impeachment purposes. Despite my request, my attorney neglected to raise this issue at trial. Furthermore, I failed to understand how the prosecution was allowed to use this man's repeatedly inconsistent and contradictory testimony, claiming that it represented substantive evidence of my guilt. I brought that to my attorney's attention, and he neglected to address the issue at trial. Now to discuss Detective Richard Webby and his testimony. Unlike the other witnesses that testified, Detective Richard Webby was not sequestered from the courtroom during the course of the trial. In fact, he was present in every court proceeding involving this case. This allowed him to cater his testimony to the needs of the prosecution. I brought this to my attorney's attention, and he failed to raise the issue at trial. In regard to his actual testimony, I had repeatedly instructed my attorney to drive home the fact that no evidence exists, aside from word of mouth, that I ever made the statements that were used against me at this trial. No concrete evidence exists to lend any credence to what Detective Richard Webby claims that I said. This fact allowed Detective Richard Webby to cater his testimony to the needs of the prosecution at trial. Some of his testimony was paraphrased and editorialized from his written reports, and some of his testimony was made from an opinionated and subjective standpoint rather than being based on objective facts. I brought this to my attorney's attention, and he neglected to address the issue at trial. Detective Richard Webby previously testified at a motion hearing that he and I conversed over a 3-hour period with only 2 short breaks in between. He testified that these breaks were just long enough for him to gather new information and return. That's a long time to be engaged in conversation, yet his written report of my alleged statements contains surprisingly few excerpts of actual conversation that took place. Therefore, I submit that my statements were not used against me. What was used against me was an editorialized, paraphrased, out of context, and false version of them, born out of the mind of Detective Richard Webby, with nothing but his own word to lend any credit to their validity. I brought this point to my attorney's attention, and he neglected to raise the issue at trial. Detective Richard Webby also testified to my alleged conduct and comments made during the taking of my DNA buccal swab. Whether his testimony was truthful cannot be proven, but the timeline he provided and greatly stressed in his testimony was grossly incorrect. This could have easily been proven by comparing the time logs of when the swab was taken in relation to when the court proceeding had concluded that day. I brought this point to my attorney's attention, and he failed to address the issue at trial. Furthermore, if Detective Richard Webby's testimony regarding that was grossly incorrect and exaggerated, then it can reasonably be inferred that other supposed facts he testified to could have also been grossly incorrect and exaggerated. I brought that point to my attorney's attention, and he neglected to address the issue at trial. I believe that it's reasonable to infer that Detective Webby's motivations in doing this were political by nature, considering that during his close involvement in this high-profile and highly publicized case, he was promoted to sergeant. I brought this to my attorney's attention, and he failed to address it in his arguments. Now on to the testimony of Dr. Jillian Davis, who saw to me in the ER. She previously testified at a motion hearing on September 26, 2012, when she begrudgingly admitted on cross-examination that there were clear signs of my injury, such as swelling and redness in the area. Yet here at trial, she testified that there was no swelling, no redness, and that I seemed to be...
At this point, his speech feels less like a plea for leniency and more like a complete attack on the prosecution's case. Detectives, witnesses, medical testimony, nothing is left untouched.
...comfortable in a clear and obvious contradiction to her previous testimony that was made under oath. I brought this point to my attorney's attention, and he neglected to raise the issue at trial. She also testified at the motion hearing in reference to my injuries that, and I quote, obviously something had to hit him to do that. She went on to further testify that my injuries were consistent with having been hit with some object. Yet at trial, she again testified inconsistently, stating that my injuries could have been sustained by yawning. I brought these points to my attorney's attention, and he failed to confront her on these clear and obvious contradictions. Her testimony was blatantly contradictory, and clearly her testimony was biased against me, and either influenced by the prosecutor or by her own prejudice. Even multiple arresting officers testified that I was clearly injured. It is why I was admitted to the trauma center of Botsford Hospital and administered the drug morphine for severe pain along with other medications through an IV. I refuse to believe that a reputable establishment such as Botsford Hospital would admit someone to their trauma center and give them an injection of a drug as serious as morphine if the individual showed no clear signs of a serious injury. There are many issues beyond what I have already made mention of that I intend to raise in my appeal. I merely hope that the appellate courts will be willing to give fair consideration to the issues that I present before them, regardless of me not specifically citing them here today. I don't believe that I was treated fairly or impartially during the course of this trial or the proceedings that led to it. Everything down to the prosecution's closing arguments and the overtly suggestive and inflammatory nature of the visual presentation they presented denied me any hope of a fair trial and engineered what I consider to be a strong miscarriage of justice. I had great potential and a multitude of opportunities at my fingertips for establishing a constructive and successful future for myself. I completed my high school education, holding a 3.8 grade point average or higher my entire senior year, and after 4 successful years enlisted as a JROTC cadet, I earned the position of B Company Commander by my senior year, taking with it a deep sense of accomplishment, satisfaction, and the respect of my peers. I have no juvenile record whatsoever, and before this incident, not a single violent conviction or any felonies on my record. Those who were closest to me and knew me on a personal level regarded me to be a kind-hearted, compassionate, intelligent, and talented, polite individual who would often go out of his way to help those who asked it of him. The implications that I planned and carried out these brutal acts of violence against individuals that I have absolutely nothing against, people that I don't know and have never met, at a place I have never been to with someone that I have been the acquaintance of for only 3 short weeks, is nothing short of ludicrous. I did not go to the Cipriano household intending to hurt anyone. I didn't go there intending to hurt anyone, let alone to kill someone. At the time, I had already applied and been accepted to the Michigan Institute of Aviation Technology, and I was a mere 2 weeks away from being able to start the first of my classes. All I had left to do was complete the forms and paperwork for financial aid to pay for my enrollment. And I will admit, yes, I formed a habit experimenting with drugs such as marijuana and spice, and by doing so, I allowed my mind to be clouded. I associated with people.
And now the tone completely changes. The legal arguments fade away, and suddenly it becomes personal. Regret, lost opportunities, bad influences. This is the moment where the emotional weight of the sentencing really hits.
People that used these drugs as well. and that was my downfall. My message to all young individuals is to look at and learn from what happened here today in this courtroom. I had a great many things lined up in my future, and now, because of my association with someone that didn't care at all about me, my life, my future, or my well-being, someone that I had known for a little less than a month, whose only common interests with me lied in the pursuit of getting high. Because of that short association, I stand before you today facing a mandatory sentence of incarceration that will span the rest of my natural life. I want to thank the true friends that have stood by me and continue to believe in me despite the horrible accusations that are being made. And most of all, I want to thank the beautiful family that God's blessed me with, who have stuck by me through thick and thin. Your letters and your cards sending love and support have gotten me through some of the darkest of times. And they mean the absolute world to me. Your continued optimism and hope has rubbed off on my heart and carried me through the darkest of hours, helping me to see that there is light at the end of this tunnel. I promise to stay strong, think positive, and work towards building a better future for myself, wherever that may be and whatever it may hold. Finally, in regard to the Cipriano family, words do very little to express the depth of sorrow that I have for all of you. If there were any way that I could change what has happened, I would do it in a heartbeat. As I've already said, I never intended for any of this to happen to any of you, and had I been aware of what was going to occur inside that house that night, I never would have even been there. Nothing that I say can change what happened. Nothing that I do can bring Robert Cipriano back to you or take away the hurt experienced by Rose or Salvatore. I pray for you daily and wish with all of my heart that Rose and Salvatore Cipriano make a full and complete recovery. I pray that all of you are able to heal in your own way from the tragic reality that has led to this day. And if my words offer no comfort for your hearts, I just want you to know that you have my condolences, you have my sympathies, you have my highest hopes, my best wishes, and my prayers that the best things possible can happen for each and every one of you, and that you can have some measure of peace and happiness in your lives despite whatever hardships that you may face in your future. My intent was not to cause any harm. The only reason that I went there that night was to assist someone that asked me to help them pick up their personal belongings. And that quickly turned into a living nightmare that none of us have been able to wake up from. And I can't tell you how sorry I am that all of this has happened. And if there was anything that I could do to take it back and find a way to change what has happened, I would do everything in my power to. And I understand that as a circuit court judge, Honorable Shalina Kumar, it's your duty and responsibility to impose the sentence of natural life incarceration because of the crimes that I've been convicted of, albeit that I feel I was wrongfully convicted. I don't think that the jury looked for reasonable doubt. I think they were looking for a reason. I don't in any way hold the sentence that is to be imposed against you or the court. I feel that I was not treated fairly. I don't feel that issues that were present were brought to the surface. And for those reasons, I will be appealing this sentence. And I again apologize if anything that I've said so far today has seemed inflammatory or has been taken in the wrong context. I merely want people to know what it is that I see plainly as day that I feel has gone wrong here. Thank you. I'm Thank you for allowing me to speak. I'm ready for the sentence to be imposed.
Mr. McCarthy, is there anything you'd like to say?
About all that?
Anything you would say?
No. I won't respond to that. If ever there's a forum where that comes up, before this court, perhaps, should some opportunity like that arise, I'd be well prepared for that. I don't think that there'd be anything gained from responding to this young man's despair here this afternoon. So I appreciate having that opportunity, but I'm going to pass it. Thank you.
Mr. Shansky, is there anything else you'd like to say for the record?
I'm horrified. Thank you.
For the record, once again, I would like to express my sorrow to the Cipriano family for what they have gone through and continue to go through. Mr. Young, for the record, I want to acknowledge that you do not have the loving, supportive home life that Mr. Cipriano had. And I want to acknowledge that. I understand.
Judge's response here is incredibly powerful. She acknowledges his difficult upbringing and possible mental health struggles, but she also makes it clear that hardship does not erase accountability. That balance between empathy and responsibility is something courts wrestle with constantly.
And you had a very emotionally and physically abusive stepfather, and that is horrific for a child to suffer. And I do wish your stepfather was here today so I could explain to him his role in this whole event, because abuse is a cycle, and I do think that has played a role in what you have turned into. I also understand that there is some sort of maybe mental disease that you suffer from, and I'm sure that has played a role as well. I'm not sure how much of what we've heard today or your actions have to do with a mental disease or that you are a very manipulative person. It's probably a little bit of both, in my opinion. Your absolute refusal to acknowledge any of your decisions or your activities in this event, your absolute refusal to take any responsibility is really unbelievable to me. You are clearly a very intelligent young man. You absolutely, without a doubt, know wrong from right. And you are very critical of Mr. Zinderman, but Mr. Zinderman was smart enough to walk away that night, knowing what the two of you were likely to do. You did not use your intellect, as Mr. Zinderman did, to walk away that night. And you could have, and you should have, and you chose not to. And you are not someone who does not know right from wrong. I do not believe the things that you are saying. I absolutely believe that you did this, you made decisions to do this, you played a significant role in this. As for Mr. McCarthy, he is an excellent attorney, and I don't think there is an attorney that could have done a better job defending you, for the record.
This may be the harshest moment of the entire hearing. The judge tells him directly that his downfall came from his own choices. In sentencing, judges often focus on personal responsibility, and this was her final message before imposing a life-changing punishment.
So you need to take a look in the mirror and really take responsibility for the decisions that you've made, because you're right, you had a lot going for you. You could have been a lot in life, but you're not going to be because of your own decisions, not Mr. Cipriano's decisions, not Mr. Zinderman's decisions, not anybody else's decisions. They were your decisions. You made the decisions on your own, and you were smart enough to know better. So you have ruined your own life, along with the life of the Cipriano family. You were convicted of first-degree murder on two theories, that being first-degree premeditated murder and first-degree felony murder. There is one sentence imposed of natural life without parole. There is 464 days of jail credit. On counts 3, 4, and 5, 23 years to 60 years, 464 days of jail credit. Crime victims' right fee of $130, attorney fees to be determined determined, state cost of $340. You must comply with DNA testing. You're to have no contact or association with the victims, Rosemary, Tanner, Isabella, and Salvatore Cipriano. You have no contact or association with the co-defendant, Tucker Cipriano. You do have the right to Court of Appeals for leave to appeal. Your attorney's going to hand your appellate rights form. If you want an attorney appointed for your appeal, you must fill the form in this court within 42 days of today's date.
Judge, in anticipation of the hearing, Mr. Young executed the request for appointment of appellate counsel, and I've seen to it that it's been completed. I'm going to give it to your clerk this afternoon before I leave the courtroom, so that that at least is on the record that he's made that request.
Okay, thank you. Anything else for the record, counsel?
Not on this case, but if I may, on the other case, if I approach after this is finished.
You want to approach you on a public first?
No,
You want to approach?
before you get up to that.